Sí, sí.
Yes, yes.
Perhaps I asked a improperly combined question. Can you afford your own lawyer? Yes or no?
No.
No.
Based upon that, do you want me to appoint the public defender's office to defend you?
Sí.
Yes.
They'll be appointed to represent you. I see that you don't qualify for pretrial release, so your bond will be $500. Don't drive without a valid driver's license. I'm saying that because when you got the DUI ticket, it also caused you to have your license suspended. Make sure you read your ticket so you understand instructions about how that works. But don't drive without a valid driver's license. All right, thank you. Your name, please.
Jorge Morán Bing.
Jorge Morani Bing.
The allegations that you drove without a valid driver's license. There's probable cause to believe the offense occurred. And it looks like you don't qualify for pretrial release. So your bond is going to be $500. Do you understand?
Exacto. ¿Y cuándo se puede pagar eso?
Exactly. When can I post that?
You can post it immediately. Or if you're unable to do it from the jail, you can go through a bondsman. Or you can have someone from outside that you contact go to a bondsman or post the money with the jail.
Al realizar el depósito, salgo inmediatamente. O sea que al pagar, salgo inmediatamente.
So once I pay, once I post it, I'll get out immediately.
So, all right. Well, it's an easy question with a complicated answer. Because before anyone is released from the jail does one last check to make sure that there's no warrants or anything out there that exists. So between the time someone pays the money, someone's got to enter that into the computer, someone's got to tell someone at the jail that you're eligible to be released, then they start the process to make sure that there's no warrants or something else out there in the system. So it's not like a vending machine where you stick the money in and out pops the candy bar. There's a delay. So when you say immediate, there is a delay. Sometimes the delay is an hour or two, sometimes it's a couple of hours. There's a note here that says something about that you're inadmissible to the United States.
He
I
has
don't
an
know if that
immigration
means that there's an
detainer.
immigration hold at some point or not.
There is, Your Honor. He has
So-
an immigration detainer.
So sometimes that detainer goes away and sometimes it doesn't. So that's why the answer is a complicated answer. The only way I can say is once the bond is posted on this case here, then this case here no longer holds you in jail once it passes the administrative process of entering it into the system. Sorry, it's such a complicated answer. It would be nice if it was as easy as a vending machine. It's just not that simple.
Disculpe. Entonces, ¿dónde voy a hacer el depósito?
I'm sorry, but where would I go to post the amount?
You mean if you have $500 in your personal property when you're arrested, can you use that? Is that the question? Or do you mean that someone you contact wants to post it, where would they go?
Un amistad mío.
A friend of mine.
Okay, so they could go to a bondsman. There's lots of them available, some of them as close as across the street. And then also, I think, let me just ask, I don't know if COVID's changed. Did you all know, do they take the money cash directly from people anymore?
No, it would be money order, cashier's check, or traveler's check.
Oh, okay, so the jail will take a money order. Those are free to get from Scott. Or a traveler's check, or, what was the other one? Cashier's check? Yeah, money orders are the easiest. But you can get those, you can get them, people can give cash to Amscot, they'll give you a free money order, and then the money order can be given to the jail. And at that point in time, I no longer have any more information. All right,
No, entendido, gracias.
Understood. Thank you.
all right, have a good day. I believe the next case is the final interpreter case, Oscar Ventura, although the paperwork also might say end with an E.
Oscar Ventura Bail.
Good morning, can you tell us your name, please?
Oscar Ventura Bail.
Oscar Ventura Vail.
And can you spell the Ventura? Is it
Con una B. B. Puede ser nomás lo que se escribe. ¿Qué es este?
Judge, if I may, it's V as in Victor, Entura.
A? All right, which looks like is what everything says in the police report here, other than when the officer typed name of defendant, he ended it with an E. So I don't know, does the jail need to have that corrected? The capias that was failure to appear, has it end with an A?
No, Your Honor.
Okay. And Mr. Horn, you see that?
I've corrected it, Your Honor.
All right, thanks. All right, so I don't know if that's wrong. It's supposed to be an A. But
We go by the warrant.
fair enough. Okay.
Your
Oh, got it. Okay, so maybe I spent more time on that than I needed. But you were picked up on a warrant for your arrest after you failed to appear for a violation of probation status, and the judge set the bond at no bond. Do you already have a lawyer, or do you need me to appoint the public defender to represent you?
Sí, pero no, más que todo no sé si no, ya creo que no tengo porque no tengo ni un teléfono en la casa, no he marcado con mi familia y total
I
no
don't.
sé.
I don't know because I don't even have a phone number. I don't have a phone at home. I haven't been able to contact my family. I don't know.
Okay, so it's a little complicated. You have Jose Toriola representing you on this case. Now, what day was the failure to appear?
Sí,
Now, I know.
Yes.
Okay. Wasn't in the last 2 weeks. Okay, got it. All right, so you have a lawyer defending you. Your lawyer will be able to schedule a bond hearing if necessary, or you'll be given the next court date pretty soon. Do we even know what the dates are?
We'll set it for in July. We're setting for Angela Raymond here. Is it a no? Because it's a no bond.
Right.
So we're setting for one, the next one. I think next available is on the 13th. But it's next.
All right, you'll have a court date next week, like this week. I mean, because today's Sunday, it's going to be this week in the next couple days, okay?
sí está bien.
But
Yes, that's fine.
But you can let people, your friends or family members know they can call Mr. Torriella and let him know that you're in custody. All right, thank you.
Sí, pero no tengo ni un números para marcar allá con mi familia.
I don't have the number in order to be able to dial my family.
Do they know you're in custody?
No sé si ya hablaron con el licenciado.
I have no idea if they have been able to speak with the attorney.
So I'm going to temporarily appoint the public defender's office as an additional attorney. When we go off the record, I'll say why. I don't want to broadcast it. But there might be some issue with regard to the availability of Mr. Torriola that has nothing to do with like with professionalism or anything like that. It has nothing to do with that, but I don't want to say it on thing, but just remind me at the end. So thank you. All right, so now you have the public defender assisting you temporarily, at least to your next court date, okay?
Yeah. Judge, he will have a good,
Sí.
next bill.
Yes.
February 14th.
Okay, yeah. All right, thank you. I think that was the last interpreter case.
Your Honor, will the interpreter be needed for any person in the public for a DV case?
You can inquire, and
¿Hay alguien en el público que va a requerir un intérprete en español? Si es así, por favor, levante la mano.
I see no hands raised.
Okay,
All
Your
right,
Honor, the
so
interpreter will
unless
disconnect.
yeah, you're excused, and hopefully no one will say, hey, they need this, they need an interpreter.
Your Honor, once I disconnect, I won't be available anymore because I will have left the courthouse.
All right, well then we'll reset one of those cases until tomorrow or so. Hopefully it won't happen. Have a good day.
Okay, you too.
Thank you.
Bye-bye.
All right, your name, please. All right, the allegations are that you trespassed and that you committed a criminal mischief, and there's probable cause to believe the offense occurred. Can you afford your own attorney, or do you need me to appoint the public defender?
Appoint the public defender.
All right, I'll appoint the public defender to represent you. You're out on bond in a couple different cases. They are no relationship to the type of charge you just picked up. Not that that really matters as far as the availability for a court to revoke the conditions, but I'm not going to revoke. I'm just going to double the bond. So count 1, 2,000, count 2, 1,000. Don't return to the location of the offense. All right, do you understand?
Yes, so I can bond out, sir.
Yeah.
Thank you so much, because the police just killed my cousin.
All right, have a good day. Thanks. Next case. Slowly. When you get to the podium, tell us your name, please.
Dennis Ramos.
All right, you're taken into custody for 2 counts of battery. Can you afford to hire your own attorney, or alternatively, if you need me to appoint the office of the public defender to defend you?
Yes, sir.
Which one?
Yes, Your Honor.
But which one? Your own attorney or the public defender?
A public defender.
All right, so I'll appoint the public defender to represent you. The bond on this case is $500 on count 1, $250 on count 2, and no contact with the listed victims. Do you understand?
Yes, Your Honor.
All right, thank you. And let's see, does he qualify for any type of mental health pretrial release?
Judge, that would be up for mental health PTR
Okay,
to
so you
review.
might be able to get out of jail without having to post a bond, because it's going to be mental health pretrial release if you qualify, or it's the 500 and 250 that I mentioned. Either way, no contact with the listed victims. Do you understand, sir?
Yes, Your Honor.
Was it a DV, Judge?
No, not a DV.
No, it wasn't.
All right, thank you. Have a good day. Yeah. All right, Cardell Cannon.
Yes, sir.
All right, so you have a couple different cases, couple different counts here. But before I begin, you do qualify for the public defender, so they'll be defending you on the case.
Thank
The
you, sir.
allegations are you committed a battery on a family or household member as that phrase is defined by law. And then the other 2 counts involve apparently your relationship with law enforcement as you were being transported. So they're alleging that you committed a criminal mischief and that you were making an improper threats to the law enforcement officer. But I want to talk about the domestic violence case, the domestic violence charge first. There's a condition that you have to have no contact with the listed victim. And no contact means nothing, no contact. The only exception is your lawyer's allowed to defend you. So other than that, no direct or indirect, no good or bad contact. No contact means no contact. It looks like you raised your hand, you have a question. I'll let you ask your lawyer the question to make sure you don't say something that hurts your case.
Permission to speak, sir.
Yeah, say it to her first.
Okay. There's no reason she did assault me. She did not have a weapon in her hand. She did not attack me in uniform. me that I got no contact with her, but me and her live at the same address. So, well, she can't stay there if they have no contact with me, because I'm an alleged victim.
All right, so no contact at all.
Qualifies for pretrial release, Your Honor.
All right, so no contact with the victim, no return to the victim's residence, except for one time with law enforcement to collect any belongings. The way that
Permission to
works is,
speak, sir?
the way that works is you contact law enforcement that has jurisdiction over the property, tell them you're allowed to return one time, and they would accompany you to the property to make sure everything goes smoothly. All right, don't possess any weapons or firearms, maintain a separate residence from the victim. The pretrial release says you qualify for pretrial release, so you won't have to post any money to get out of jail. But if you violate any of these conditions, it's going to cause you to be right back in jail. Do you understand?
So did you just question permission to speak, sir?
Well, you can ask me a question, but before you do, a couple things.
Okay.
Everything's being recorded. The state attorney's right there. He's the one prosecuting you. And I can't tell you how many times people wanted to say something to me and it ended up hurting their case. I won't stop you from saying it. I'm going to give you one last warning before you tell me what you want to tell me. My family always says, what's going on in court? Tell me a good story. And the stories always begin, I told the defendant not to say anything in court, but they wanted to tell me something anyway. So I'm running low on stories. So if you want to be that person that provides information to tell me that the state's going to use against you and that I'll be able to tell my family that someone said something that's going to hurt their case, I'm going to let you say it.
Yes, sir. Okay. Permission granted, sir? Did you
I
just
won't
say?
stop you from speaking,
10-4, sir. Did you just say I won't have to pay any money to get out?
right?
So I'm assuming that's an ROR, or
Yeah.
what type of release would
It's
that
called
be?
pretrial release. You're
Okay.
supervised by the pretrial release officer. You have those conditions of the no contact, the maintain
Okay.
separate residence, no weapons or firearms, and no return. And so what happens is if people violate the conditions, the pretrial services can, within like one click of the mouse, send over the warrant to the judge to sign so the judge can sign it. And then before you know it, someone's picked up again. And so you understand that?
Yes, sir. Thank you, sir, for the
It
clarification.
doesn't mean that the charges aren't serious, and it doesn't mean that the state can't prove the allegations against you. Don't interpret it that way. All right, anything else?
I couldn't hear you, sir. The officer was
Yeah.
interrupting
It doesn't mean, it does not, sometimes people misunderstand being able to get out of jail without having to post a bond. It doesn't mean that the charges aren't serious. It doesn't mean that the state can't prove the allegations against you. It doesn't mean that you couldn't be sentenced to jail if you're found guilty. It just means that you don't have to post money to get out of jail. That's all that means.
Yes, sir. Thank
Understand?
you for the clarification, sir.
Anything else?
No, sir.
All right,
Thank
well-
you for your time, sir.
And thank you for not giving me anything to tell my family. All right. All right, when you get to the podium, tell us your name, please.
My name is David Allen.
All right, Mr. Allen, hold on just a moment. All right, so I'm going to use this case. Can you hear me okay?
A little bit better, sir. Thank you.
All right, I'll do my best to speak louder.
That's fine.
and,
Thank you.
All right, so I'm going to use this case to talk to you and everyone else who's in the audience because it's easier for me to say this one time than it is for me to say it over and over again. If I see that someone who's likely the victim of the case is here, that's fine. But if the victim wasn't here, I would order, in any case, if the victim's not here, I have to order a couple things: no contact, maintain separate residence, no weapons or firearms, don't return to the scene of the victim's residence. Sometimes, though, the victims come to court and they want to tell me something, and sometimes they want to talk to me about something that's relates to the condition of this contact, whether I should order the defendant to have no contact with the listed victim. It should make sense to everyone who's a listed victim that you're more protected if I say no contact than you are if I allow there to be contact. Sometimes the listed victims come in and they tell me they want there to be only contact by phone or by email. Sometimes victims tell me that they want there to be as much contact as I allow. The term of art for as much contact as the court will allow is something called no hostile contact. So no hostile contact would mean no more contact with the victim than the victim allows, so long as it doesn't otherwise violate the law. Like no person's allowed to tell someone else, hey, take that hammer and break my hand. That would be against the law even if a victim said to do it. But if the victim said you can be around her and you want to be around her, that's fine as long as you would abide by the restrictions, such as if she says, don't yell at me, you couldn't yell at her. If she says, don't be around me after you've been smoking cigarettes, then you couldn't be around her after you've been smoking cigarettes. They can't use it to say you have to do the dishes. They can't make those kind of conditions, but they could restrict contact. But the problem is, if I allow the no hostile contact in any case, I'm putting you at more danger than if I ordered no contact. Because if no contact, you shouldn't be around each other. But if it's no hostile, then you might allow yourselves to be around each other, and before you know it, you're back here. Or I've seen other cases where you're the listed victim one day, and the next day you're all in the different positions because of things, how they go. You obviously know, the listed victims obviously know the defendants more than I know them. All I did is read a police report. With that being said, we'll go through this here. So first question to Mr. Allen, starting at this point, is can you afford a lawyer, or do you need the services of the public defender?
I can afford a lawyer, sir.
All right. So today, I'm here to tell you that you were arrested for battery on a person over the age of 65, and also for the offense of misdemeanor battery. The listed victim is Ms. Finley. So let's see. Raise your right hand the best you can. Do you swear or affirm the information you're about to tell us is true and correct?
Absolutely.
Thank you. You can put your hand down and tell us your name and how you're related to Mr. Allen.
Sharon Finley. We've been boyfriend and girlfriends for 10 years, 1 month, and 10 days.
All right, thank you. All right, so are you asking me to allow Mr. Allen to have contact with you?
No.
So you want it to be no contact?
No, because my face is all messed up. I'm afraid I don't want to go through this again.
Okay, so just to be clear, you want me to order he have no contact with you?
That's right.
Okay. And you want me to order that he maintain a separate residence from you?
Yes.
And you want me to order that he not possess any weapons or firearms, I take it?
Yes.
All right. He obviously has belongings at your house?
I have no issue with that.
All right, so the way that works is Mr. Allen, you would contact law enforcement. You would tell them you're allowed to return one time. I promise you won't be the first person that tells them that. They have a procedure. The procedure is they will meet you somewhere other than the property, and they'll accompany you to the property to make sure everything goes smoothly. You understand that?
Yes, Your Honor.
If you just go to the property, you're just going to get arrested.
Yes, sir.
The next thing I want to tell you, and I just want to make sure everyone understands this, is I have no idea tomorrow whether, Ms. Finley, you change your mind or not. I'm not saying you ever would, but I'm using this as an example here. If tomorrow you're thinking, oh, you know what, I'd like there to be contact again, you can't change it, only the court can. Now, sometimes what happens is the lawyer representing, say, Mr. Allen for you, I'll use your case since you're here, your lawyer might schedule a hearing in front of the judge to modify the conditions and allow there to be contact. If the judge allows that, then it modifies it. But as long as the case is pending, or until a judge signs an order modifying the no contact, it's just no contact. And I just want to make sure we're all on the same page here. No contact means no good or bad, no direct or indirect.
Yes, sir. None whatsoever. I understand, sir.
All right. So now I'm going to ask the pretrial service. Oh, I got my list here. No prior criminal history, correct?
Your Honor, he does have prior criminal history for DUI, battery, distribution of heroin, and vandalism.
But it says no felonies, no misdemeanors, no failures to appear. Does that mean
Convictions, Judge. He has arrest history, no convictions.
Oh, arrest and no convictions. All right.
Yes, Your Honor.
Does he qualify for a pretrial release?
Yes, Your Honor.
Okay. So now listen. You don't have to post money to get out of jail, but that doesn't mean that the charges aren't serious, and it doesn't mean that the state can't prove the allegations against you. It just means you don't have to post money to get out of jail. But if you violate any of the conditions, it's going to cause you to be right back in jail.
Yes, Your Honor.
And if he violates any of the conditions, you can contact law enforcement or it could the pretrial release office and let them know. And then really it takes very little effort from them to get me to sign a warrant to cause people to go back in jail. So, you understand, Ms. Finley?
Yes, Your Honor, I was told by the police last night that coming here that I would see a state's attorney and then some advocate for
See,
domestic
the gentleman
violence.
to your right there is with the state attorney's office. He might be able to tell you, I can't tell him to do many things, but it looks like he's got a business card.
Your Honor, I have a card for her to reach out to the office. It'll get assigned to somebody in the office, and maybe they can pass it through to them.
Okay, go ahead.
Thank you.
Anything else, ma'am?
No,
All right, thank you all, thank you all.
Thank you, Your Honor.
have a good day.
Should I grab my gear?
What at one time?
Okay. Yes, ma'am.
The next case is going to be Cannon to Cassidy.
And Judge, only because we had a similar situation yesterday. She is the sister and victim in Mr. Cannon's case that we just addressed. I know yesterday we brought out a brother and sister when you wanted to ask about the type of contact. I don't know if the court wanted to do that again.
He's already mad. That was the first guy that you was asking questions.
I'm sorry? Oh, never mind, Judge. We can deal with the contact stuff once they're assigned to an attorney in our office.
Fair enough, okay. Your name, please?
Cassidy Cannon.
All right, thank you. Can you forward an attorney, or do you want me to appoint the public defender?
A public defender.
All right, thank you. I'll appoint the public defender right now. I see you filled out that paperwork already. Sorry to even have to ask you the question. So the public defender will be appointed to represent you. Now I'm looking at my notes on the case. All right. There's probable cause to believe the offense of aggravated assault occurred. Now I'm about to set conditions of release in the case, but I have to order the following. No contact with the listed victim. Maintain a separate residence from the listed victim. Don't possess any weapons or firearms. And you can't go to where the victim resides except for one time with law enforcement to collect your belongings. And the way that works is you'd contact law enforcement, tell them you're allowed to return one time, and they'll accompany you to the property to make sure everything goes smoothly. Do you understand all of that so far?
Yes, sir.
Okay. So now about to hear, let's see, it looks like, does she qualify for pretrial release?
Yes, Your Honor.
All right, so you won't have to post any money to get out of jail. Oh, and I forgot to, I said no weapons or firearms include like bats, crowbars. You won't have to post any money to get out of jail, but make sure you comply with the conditions of release, okay?
Yes,
Right.
sir.
Thank you. The next case, oops, is going to be, your name, please?
Stephanie Banks.
Thank you. Raise your right hand the best you can. Do you swear or affirm the information you're about to tell us is true and correct?
Yes.
Thank you. And if you could just get a little bit closer to that microphone, apparently it's designed for people who are about 4 foot tall. So, all right, so hold on just a moment. Can you tell us your name, please, ma'am?
Alicia Mobley.
One more time?
Alicia Mobley.
Okay, you're the listed victim in the case here, and you've heard me give my speech just a minute ago. All right. So, sir, you're alleged to have committed an aggravated battery, which means on a pregnant person. It means a battery on a pregnant person. It just becomes a felony because the person is pregnant. There's probable cause to believe the offense occurred. Can you afford a lawyer, or alternatively, do you want me to appoint the public defender?
I can't afford a lawyer, I'll do a public defender.
So therefore,
I can't afford a lawyer, I'll do a public defender.
okay, thank you. So I'll appoint the public defender. You heard me explain about the difference between no contact and no hostile contact, and how you're more protected under the no contact than you are in the no hostile contact. You understand all of that?
Yes.
And which of those are you asking for in this case?
We can have contact.
Okay, it sounded like you said he can have contact, but for whatever reason, when they built this, they put the speakers everywhere except above me. So if you could just be a little bit louder.
Yes, I was saying we can have contact.
Okay, I definitely heard you say that. Okay. Are you afraid of him?
No.
If are you asking me to order him to live somewhere other than you?
No.
All right. If for some reason he touched you against your will, would you feel comfortable calling the police?
Yes.
Sometimes the attorneys want to ask questions of the listed victim. I'm going to let them ask. The person closest to you is with the state attorney's office. The person further from you is with the public defender's office. I will tell you though, I don't know if you had a chance to read the police report, but the police report also indicates two things: that you didn't want to prosecute, but also that the police officer might have forwarded a copy of the report to the state attorney's office for them to investigate whether or not the charges should be filed against you, just so you know that. And so also one last thing, even if I allow contact, that doesn't mean he has to have contact with you. I mean, it just would allow it if everyone's okay with it. Okay, so State, do you have any questions for her?
Just briefly, Your Honor, you have another child in the home,
Yes.
and he was there during the incident?
Yes.
No further questions, Your Honor.
Defense?
The court already asked my questions, Your Honor.
All right, so, sir, no hostile contact means no more contact with her than she allows. Like if she says to you, don't raise your voice at me, you couldn't raise your voice at her. It doesn't mean you have to have any contact. Like, as far as I'm concerned, you can not talk to her ever again, as far as this case is concerned. There might be, obviously, I don't think that'll happen if there's children involved, but I'm just using that as an example. Do you understand that?
Yes, sir.
All right, and so let's see. Does he qualify for pretrial release?
Yes, Your Honor.
Okay, you won't have to post any money to get out of jail, but your conditions of release are going to be pretrial release, no hostile contact with the victim, don't possess any weapons or firearms. The quickest way to get back into jail is to violate the no hostile contact. Do you understand? Okay.
Yes, sir.
Thank you. Next case looks like Katerina Fedotova. Can you tell us how to properly say your last name?
Fedotova.
Fedotova. Very good. All right. So can you afford to hire your own attorney?
Yes. She's already hired. She's
Already hired. Okay. Sometimes people come to sometimes people at the IAs, they want their lawyer to be present and they have the case rolled over to the next day. However, sometimes defendants don't like that because it's at no bond. Other times, defendants want me to go forward today even though they don't have their lawyer, and your lawyer can always schedule a hearing to try to modify the conditions later if for some reason you can't do them today. Is that what you would prefer?
Yes, we can.
Just go today.
Yes, please.
Got it. All right. I don't see the listed victim in the audience because if they was, they'd be in that little room there. So I have to order the following conditions when the victim's not here. No contact with the victim. Maintain a separate residence from the victim. Don't possess any weapons or firearms. And don't go to the victim's residence. It looks like you had different addresses anyway, so that's not an issue. So that's why I say don't go to the victim's residence. All right. Let's see. Although one of the listed persons here is this Thomas Williams, who you do live in the same address with, right?
No.
No?
He lives
Okay.
at 900 Pine Street. I left him 4.5 years ago, and I have my own house on 714 Springdale.
Okay, hold
He
on,
lives
let me
at Pine Street with his mother, and the Springs house is mine. Where I live there with my son.
All right, so
And
I'm not saying what the police officer says is true, but for whatever reason on the victim page, they listed that Springdale Road address as the address of,
it's not. We have not been lived together in 4.5 years.
I understand.
And in the police report, it says over here that the police officer arrived at 900 East Pine Street at Thomas's house. And then it says over there that, then we went to Katerina's home at 714 Springdale.
And
Thomas
you-
has no access to my house.
Got it. When pretrial service, do you know the phone number? I don't want you to tell me the number out loud, but do you know the number for Mr. Williams?
Yes.
The phone number?
Yes.
Okay, so, and it looks like pretrial services might have tried to call them to.
He did, our son has a BMX race, there was there yesterday and today, so they're in Daytona. So probably the reason why they were not able to pick it up. I spoke with the DCF, with the Child Protecting Services, and we are meeting this afternoon. He's gonna, as soon as we're gonna get out, my assistant is going to place the bond, and he's gonna meet me at the house along with my attorney too, so. These
But hold on just a moment.
I'm sorry.
So qualifies for pretrial release?
We were unable to verify her community ties, Judge, and no victim contact was made. A voicemail was left for the alleged victim.
All right, so the bond on each of these counts is $250, plus pretrial release with the conditions that I mentioned. Do you understand?
Okay.
All right, but if you violate the conditions, it'll cause you to be right back in jail. All right?
May I ask a question, Ina? So,
Before you ask, just don't say anything about the facts
no,
of the case.
no. Just our son's primary residency is at my house. How do I pick him up? How do I don't know. I'm sorry. This
Well, I
was
don't know.
falsely accused. So I've never been here. I don't have a violation, anything.
But you
on
have a
my-
lawyer, though.
What?
You have a
Yeah.
lawyer.
Yes.
So your lawyer will be able to answer that question for you.
Okay.
Because all I say is it's no contact. See, this case is different than, I have no idea if you had a paternity case or a divorce case, and I don't want to get into those details, so I'm not modifying anything in that case. I'm just saying it's no contact in this case. However, some people have, time sharing, and they just drop the child off at a spot and they pick it up and they meet, in
what we
regular
have.
life. It's like let's say it's a McDonald's. I bring the kid to McDonald's, you take the kid home from McDonald's.
That's how our situation is.
Well, that's not, but right now it's no contact.
Okay.
And until that gets modified, it's no contact at all. So I don't know.
Like even by phone?
I cannot give you advice on how to trade the children. Your lawyer is going to have to get that worked out in a court order.
Okay.
All right, good luck.
All right. Thank you.
Yes, ma'am. Thank you. Dwight Gordon? Hi, Mr. Gordon? All right, thank you. All right, so there's, you qualify for the Public Defender's Office. They'll be appointed to represent you in this case. Give me a moment just to get to my notes here. All right, there's probable cause to believe the offenses occurred. The offenses are attempted first-degree murder, battery by strangulation, and battery.
Judge, I did have a PC challenge whenever the court
Yeah, I'll listen.
wants me to.
To which count?
To count one, the attempted murder in the first degree. The police report itself directly negates the first degree murder part of the attempt. There's no premeditation there. The probable cause for the murder part of that charge is that he said, allegedly he said, I'm going to kill you, but it was post the act that was intended to allegedly cause her death. So there's the premeditation part there. There is no probable cause. I'd also argue for any other elements, but in terms of the first degree murder, there's no probable cause for that.
I think that the strangulation would be sufficient on any case to get an attempted first-degree murder. But I'm going to give him a bond. This isn't, I think based upon what's here, I doubt it will be charged attempted first-degree murder, but as far as probable cause, it's at least there.
Understood.
So, and I was just going to, sometimes it's interesting what gets qualified for pretrial release or what doesn't, but I see the charge makes it not eligible for pretrial release, but I was just curious. So, all right, so no prior criminal history is what you all are showing from pretrial release.
Correct, Your
All right,
Honor.
very good. All right. So I have to order a couple things. No contact with the victim, no weapons or firearms. You can't go back to where the victim resides, and except for one time with law enforcement to collect your belongings. And I understand that the notes say here that there might be a charge against the listed victim here with regard to this bar stool, but that you captured on video. Part of it captured on video. So no contact, maintain separate residence, no weapons or firearms, can't return to the scene except for one time, return to the victim's residence except for one time with law enforcement. The bond on the case is going to be $2,500 on count 1, then $1,000 on count 2, and $1,000 on count 3. But now, just to make sure, you're saying I can't even add pretrial release?
Per the administrative order governing pretrial release, we're unable to supervise any murders or homicide charges.
So I could, hold on. Make sure. I can't say pretrial release on counts 2 and 3?
You could, Judge.
Okay, so on counts 2 and 3 only, you'll be on pretrial release after you post the bond. On count number 1, you still have to post the bond, but you won't be on pretrial release. It's at the end of the day, you won't even notice the difference. You'll have to post the bond, and you'll be on pretrial release. If you violate any of the conditions, it's going to cause you to be right back in jail. Do you understand? All right, thank you.
And he has an immigration detainer as well, Your Honor.
All right. Is that something, when it's printed out, I didn't see that on there.
Right here under the detainer section, Your Honor.
Oh, in bold, got it. All right, so what that means is after you post the bond, immigration may or may not pick you up. If they don't pick you up, then you'll be released, and if they do pick you up, well then, after you post the bond, you'll be taken to wherever they take people. So, all right, do you understand? I don't understand what the federal government does a lot of times, but all I can tell you is that there's an immigration hold. It may or may not be valid. It may or may not matter. But I just want to let you know that if there's, after you post the bond, if you don't get released, that it could be because they're trying to figure out that hold.
Judge, would you mind repeating the bond amounts for count 1 and 2?
I'll let the clerk do it.
2,500 count 1, 1,000 count 2, 1,000 count 3.
So 2,500, 1,000, 1,000?
Plus pretrial release on count 2 and 3, yes.
Thank you.
Hi, your name, please?
Orlando Rodriguez Otero.
All right, thank you. The allegations are that you committed a battery on a person over the age of 65 and that you committed a battery on a family or household members. That phrase is defined by law. Can you afford a lawyer? Do you need the services of the public defender?
Yes, sir.
Which one?
Oh, no, of the public defender.
All right, so they'll be appointed to represent you in this case. There is probable cause. Since the victim's not here, I have to order that you have no contact with the victim, don't possess any weapons or firearms, can't go back to the victim's residence, except for one time with law enforcement to collect your belongings, and you have to maintain a separate residence.
All right, sir.
Everything good? All right, perfect. All right. So do you understand all those conditions?
Yes.
All right.
Yes, Your Honor.
All right, so I saw that there were a number of, he only has one misdemeanor conviction, but I saw that he's got lots of cases, 4 in the last year, involving him and the listed victim here, but each one of them dropped by the state.
Yes, Your Honor. The notes that I have is it was the same victim as in the previous 7 domestic violence arrests, the last being on November 21st of 2020. I believe that was no info.
Got it. All right, so your bond on count 1 is going to be $2,500. The bond on count 2 is $1,000. Make sure you follow through with these conditions. And I'm sure someone has advised you at some point in time in your life it's probably time to move to another location once this, even after this case is over. But right now, you do have to maintain a separate residence and have no contact with the victim. If you violate the no contact order, it's going to cause you back in jail, held no bond, okay?
I understand, sir.
I apologize, Your Honor.
Oh.
It's just really hard with the mask. I didn't hear the bond again.
2,500 count 1, 1,000 count 2.
Thank you.
And then once you post the bond, then you'll be supervised by the pretrial release office to make sure you're not violating the conditions of release.
All right, Your Honor.
Okay. Thank you. Philip Walker, are you, sir? All right. Mr. Walker, can you, hold on. You qualify for the public defender's office. They'll be appointed to represent you on the case. It's alleged you committed a battery on a person over the age of 65. I don't see the listed victim standing up, so therefore I'll have to order that you have no contact with the listed victim, that you maintain a separate residence from the listed victim, you not possess any weapons or firearms, and you not return to where the victim resides except for one time with law enforcement to collect your belongings. You'd contact law enforcement. They'll tell you the procedure. Don't just go to the property. And looks like the listed victim was listed as your father. All right, so one moment. All right, there's a note on from pretrial services. It says he has extensive domestic violence cases. If you can just elaborate before I set the bond amount.
Your Honor, the only information that I have is what was provided by the officer. What you have, the extensive criminal history, including domestic violence cases. Were you wanting specific
No, I
convictions,
didn't know if you had
Judge?
it. If you don't have it, that's fine. I just.
Your Honor, I have it if you need it, Judge.
Yeah, go ahead.
Your Honor, 2021, 2020 battery on a person 65 years or older, dropped, disorderly intoxication, adjudication withheld. Battery person 65 years or older, dropped 2018. Petty theft 2017. And then history dating back to, extensive history dating back all the way to 1998, Your Honor. Including batteries, resisting, possession of alcohol, petty theft, burglary, conveyance, et cetera, Judge.
Right, and so according to that, he hasn't had a failure to appear since 2004?
Yes, that's correct, Your Honor.
All right. So your bond is going to be $3,500 plus pretrial release, plus including the conditions that I mentioned. Do you understand, sir? Okay, so you're going to post the bond. Then you're going to be on pretrial release. No contact with the victim, your dad. Don't possess any weapons or firearms. Can't go to the victim's residence except for one time with law enforcement to collect your belongings. And you have to maintain a separate residence from your dad. And those are the conditions in the case. And the conditions remain unless and until the case is over, at which point in time, if the state drops the charges, then the conditions go away. If you pleaded the charges, there might be the same the judge might impose the same conditions, might impose more, might impose less. Or it's possible you might have a hearing in front of the judge to modify the conditions, but these are the conditions until the case is over or modified. Understand? All right, thank you. Next case is Willie Young. Hi, are you Willie Young?
Yes, sir.
All right, you're taken into custody on an arrest warrant. The charges: assault, battery, burglary of a dwelling with an assault or battery therein, battery by strangulation, false imprisonment, and tampering with a witness to hinder communication to law enforcement. The burglary of a dwelling with assault or battery therein is based upon an allegation of leave, I'm not leaving, and therefore remaining in a structure with the intent to commit a crime therein. That's why that charge is there. So I'm here to set conditions of release in the case. Based upon your paperwork here, you qualify for the public defender. They'll be appointed to represent you. The listed victim, Taisha Hill, is not here, so I have to order the following: that you have no contact with the listed victim, that you maintain a separate residence from the listed victim. It looks like you already live in separate places, that you don't possess any.
Together.
You live in separate places.
No, we stay together.
Stay together. Let's see.
That's why I was tripping about the burglary charge.
Hold on.
Like,
Oh, well.
no.
Right. What I'm about to say is not designed for you to respond. I just listen, because I don't want you to say you agree or disagree. I just want you to at least understand where it is that I came from with that information. On the above date and time, at approximately 2200 hours, she was at her above listed residence with her boyfriend of 2 months, Willie Young. A dating relationship was established between Hill and Young. According to Hill, Young does not reside with her, however, comes over frequently to visit. So that's at least where that information comes from. So therefore, what I do is I order no contact with the victim, that you maintain a separate residence from the listed victim, that you don't possess any weapons or firearms. You're not allowed to go to her place, but I recognize you might have some stuff there, even if it was your place too. For now, you're allowed to return one time with law enforcement to collect your belongings. The way you do it is you contact law enforcement, tell them you're allowed to return one time. They'll meet you somewhere other than the property, and they'll accompany you to the property to help you retrieve your belongings. You understand all of that so far?
Yes, sir.
All right, so now I'm going to hear from pretrial services. Let's see. So he had failures to appear, but the last one was in 2013. If I'm just want to make sure I'm reading this right.
Yes, Your Honor.
And let's see, and he was released from prison in 2019.
Correct.
So I have no idea if the state is even going to file these charges, or if they do. But if they do, he's a prison releasee reoffender. Maybe you don't know that from where you came from in county court to juvenile. But the burglary with a burglary dwelling with assault or battery therein has to qualify for someone for a prison releasee reoffender if they proved it. But I have no idea whether or not how that's going to get charged. So, but here to do the set conditions of release. So what's going to happen is your bond's going to be as follows. On the strangulation charge, the bond is going to be $5,000. On the false imprisonment, the bond's going to be $1,000. On the assault charge, the bond's $1,000. On the battery, the charge is $1,000. On the burglary of a dwelling with assault or battery therein, going by what the arrest warrant says, which at this point in time I have to believe is true, the bond is $5,000. Is there one that I missed? Oh, 250. That'll remain 250. 250.
1,000, 1,000, 5,000, 5,000, 1,000, 250.
Right, and then I can put him on pretrial release after he posts the bond for all of them except the burglary of a dwelling with assault or battery therein.
Yes, Judge.
Okay, so he will be on after you post the bond, you'll be on pretrial release for all the charges except for number 3.
All right. Sir, what do you mean besides number 3, like on?
All right. So what happened?
They gonna handle everything else?
You won't notice the difference. You'll be on pretrial release. The only difference is I can't put you on pretrial release after you post a bond on count number 3.
Right.
But since you have the other charges, I can.
Right.
Some people, all their charges, I can put people on pretrial release, but that one, you will not be on pretrial release for that count. It's just, but for you, you're going to be reporting to pretrial release. You won't feel the difference.
You got a bond plus pretrial.
Bond plus pretrial release, right. So post the bond, and then you'll be supervised by pretrial release on all the counts except one of them, but you still have to report to them. It's not like you're showing up on Monday for count 1 and Tuesday for count 2. When you report to pretrial release, you report to pretrial release.
All right, thank you, sir.
So, all right.
I'm good.
Remember, don't violate any of these conditions, or it'll cause you to be right back in custody.
Yes, sir.
So, and one last thing, because one of these is a very serious charge. Even if the victim were to call you and say, I love you, I miss you, come back to me, not that she'd say that, but even if she did that, if you violate the conditions of release, you're back in jail. These are the conditions as long as the case is pending or until modified by a judge. All right, thank you.
Okay. Thank you, sir.
Next case is going to be Kristen Appling. Is that you? All right, thank you. All right, the allegation is that you committed a battery on a family or household member. That phrase is defined by law. You qualify for the public defender's office. They'll be appointed to represent you. I don't see someone in the witness box, which means the victim's not present. So without the victim here, I have to order the following. No contact with the victim. Maintain a separate residence from the listed victim. Don't possess any weapons or firearms. You can't go to where the victim resides except for one time with law enforcement to collect your belongings. And let's see. You might qualify for straight pretrial release.
Yes, Your Honor.
All right, so you won't have to post any money to get out of jail, but if you violate any of these conditions, it's going to cause you to be right back in jail. Do you understand?
Yes, sir.
And just to be, there was a note here that the pretrial services thought that the victim was planning to attend. So let me just check. Is there a Troy Appling here? No Troy Appling? Okay. So sometimes what happens is victims want there to be some sort of contact, but they have to go through the lawyers and the judge to modify that. My very first case that I had today was a person who presumably the victim said, come and hang out with me, and then the person got arrested. So don't be that person. It's no contact. as long as the case is pending or less modified by the court. The next case is going to be a Darrell Clark. Hi there, are you Miss Clark? All right, thank you. So let's see. You qualify for the public defender. They'll be appointed to represent you. The allegation is that you committed a battery on a family or household member, as that phrase is defined by law. And now we're here to set conditions of release. All right. Since the victim's not here, I have to order that you have no contact with the victim. No contact means no good or bad, no direct or indirect contact.
Yes,
And
sir.
so no contact with the victim. You have to maintain a separate residence from the victim. Don't possess any weapons or firearms. You're not allowed to go to where the victim resides except for one time with law enforcement to collect your belongings. Let's see. And then don't possess or consume any alcohol. Now I'm about to see about prior criminal history, of any, for me to determine whether or not you qualify for a straight pretrial release or not.
Your Honor, the defendant only has one prior arrest for battery DV with an unknown victim. For the record, the victim did call back and advise that he was going to try to make it to court and that he did want contact.
All right. Let's see, is there it was a Gene Rowe Jr.? Gene Rowe? Anyone here on Ms. Clark's case? All right, so oftentimes the listed victim wants there to be contact, but until the court changes it, it's no contact.
Yes, sir.
I don't know if you'd come into the courtroom or when I told that last person, but if sometimes victims say they want there to be contact, then they don't go through court, and then before you know it, people get arrested for violating the no contact order. But she does qualify for a pretrial release, right?
We were unable to verify her community ties, Judge. The charge does qualify.
So it could be court ordered, is that what you're
Yes,
saying?
Judge.
Okay, so I'll order pretrial release. You won't have to post any money to get out of jail, but don't violate the conditions of release or it'll
Yes,
cause you
sir.
to be right back in custody. Do you understand that?
Yes, sir.
All right, thank you. Good luck.
Just for the record, Judge, the alleged victim was here, but he didn't have an ID, so he wasn't.
So is he downstairs?
He left.
Okay.
Come on, sir.
Hi there, your name, please?
D'Angelo Edwards.
D'Angelo Edwards, okay.
Yes.
You qualify for the public defender. They'll be appointed to represent you. The allegation is you committed battery on a family or household member, as that phrase is defined by law. I see some people in the witness box. The clerk will swear them in.
Raise your right hand. Do you solemnly swear upon the testimony you give be the truth, the whole truth, and nothing but the truth?
Yes.
State your name for the record.
Barrington Maddie.
If you get a little bit closer to that microphone,
Barrington Maddie.
pretend like you have to yell at that microphone, apparently, because you're a tall person. And
Okay.
so tell us your name again.
Barrington Maddie.
Are you this gentleman's brother?
Yes.
Okay. And you're the person who's the listed victim in this particular case? You're...
Yes.
right,
Yes,
okay.
sir.
So did you hear my speech earlier about the difference between no contact and no hostile contact and how you're more protected under the no contact than you are under no hostile? Did you hear all that?
Yes, sir.
Are you asking me to are you asking me to allow your brother to have contact with you?
Yes, sir.
Are you afraid of him?
No, sir.
Who's that person next to you?
My mother.
That's your mom?
Yeah, my mom.
Okay. Do you two brothers share the same mother?
Yes.
Okay.
Yes, sir.
Is your mom putting any pressure on you to say anything today?
No.
Okay.
No.
Let's see. All right. Sometimes the prosecutors, the gentleman to your right, or the attorney for your brother over there, they might have some questions for you here, so we'll find out together.
Okay. Nothing from the state, Judge.
Nothing from the defense, Judge.
If he qualifies for pretrial release?
Judge, we weren't able to establish any community ties for him. Mr. Edwards advised pre-trial that he's currently transient and unemployed, and we weren't able to establish any community ties for him.
But I get court order since the victim's here?
Yes, Judge, you can.
All right, so he doesn't have to post any money to get out of jail, But there's a condition of no hostile contact. I want to explain what that means is no more contact with him than he allows you to have.
Okay,
So if he says, don't talk to me, you can't talk to him. If he says, don't smoke cigarettes around me, then you can't smoke cigarettes around him, okay? He can't force you to be around him, right? So if you don't want to talk to him again, that's your prerogative. But I'm saying here is there's not going to be a court restriction preventing contact so long as it's not hostile. Like there's no reason to touch him again. You understand? Okay. All right, good luck. Thank you all.
Yeah, okay.
He won't have to post any money to get out of jail. He'll be released later today.
Okay, thank you. Have a nice day, sir.
All right, your name, please?
Brayden Hodge.
All right. All right, raise your right hand the best you can. Do you swear or affirm the information you're about to tell us is true and correct?
Yes.
Thank you. All right, so sir, the allegation, well, let's say you qualify for the public defender's office. They'll be appointed to represent you. It's alleged that you committed a battery upon your family or household member who's here today. Did you hear my speech earlier, ma'am, about the difference between no contact and no hostile and how you're more protected under the no contact?
Yes, sir.
I don't know what you're about to tell us, but from your perspective, has anyone made any promises or threats to get you to say anything here today?
No, sir.
So are you asking me to order that Mr. Hodge, for your protection, have no contact with you?
No.
You want him to have some contact?
Yes.
What type of contact would you like him to have?
All contact.
Like the no hostile contact?
Yes.
All right, sometimes the state attorney, sometimes the public defender, they want to ask questions of the listed victim. Before they tell you, I want to advise you that it looks like my recollection from the report said that they might have sent over a packet to the state attorney's office for the state to review whether or not to file charges on you also.
Okay.
So state, do you have any questions for her?
Good morning. Do you have any children in the home?
Yes.
No further questions, Your Honor.
Nothing from the defense judge. He qualifies for pretrial release, Your Honor.
He qualifies for pretrial release.
Yes, Judge.
Okay. So, all right, you won't have to post any money to get out of jail, but you'll have the conditions of no hostile contact, which means no more contact with her than she allows you to have. She says, stay away from me, you have to stay away from her. She says, you can be around her, you can be around her, but she can't have hostile contact. Make sense?
Yes, sir.
All right, so do you want him to be ordered to live somewhere else from you, or
No.
No, don't want that? All right, so it's just pretrial release, no hostile contact, keep in contact with your lawyer. The case is still pending, even though you don't have to post money to get out of jail. All right, good luck to you all.
Were we appointed on that case?
Yes, ma'am. All right, your name, please?
Mark Jimenez.
You qualify for the public defender. They'll be appointed to represent you in the case. The allegation is that you committed battery on a family or household member. Is that phrase is defined by law? I don't see the listed victim standing up. Therefore, I have to order the following conditions. No contact with the listed victim. Don't possess any weapons or firearms. You have to maintain a separate residence from the victim, and you're not allowed to return to the victim's residence except for one time with law enforcement to collect your belongings. No contact means exactly that, no contact. If you violate the no contact order, it'll cause you to be right back in custody. And it looks like there might be 2 listed victims. Hold on. Laura Bouchine and Brent Young. All right, so let's see. He qualifies for all right, so you won't have to post any money to get out of jail, but if you violate any of those conditions, it'll cause you to be right back in jail. Do you understand?
I do understand. May I speak for 1 minute, please?
Say it first to your lawyer before you say it to me, otherwise
Sure.
it might be something that hurts your case.
All right.
We're good, Your Honor.
All right. That's all, thanks. All right, your name, please?
My name is Auntie Lamb.
The allegations are you violated your conditions of pretrial release on a domestic case. State, what's the status of the 2020 MM9224?
Your Honor, the state received that case on 12/31. The filing decision has not been made yet. Arraignment scheduled for January 21st, 2021.
So still pending.
Yes, Your Honor.
All right, so on your new case here, to be clear, I'm going to order no contact with the listed victim. No contact means no good or bad contact, no direct or indirect contact. The condition of no contact remains as long as the case is pending or unless modified by a court. As I believe I said before, you qualify for the public defender. They'll be appointed to represent you. Your bond is going to be $2,500, but now you're going to have to go back in front of the judge on that domestic violence case to readdress your conditions of release in 2020 MM9224 because the conditions of release are being revoked. But you're entitled to have them readdressed by the judge in that division, Judge Shoemaker. So do you already have the public defender's office defending you on that case too?
Yes.
Okay, the clerk
I
says
haven't
yes.
talked to them.
What's that?
I haven't talked to anybody from there. They
Right.
didn't have my paperwork.
All right, so we'll put it on there for sure that the public defender's office is previously representing you, and we'll continue. And they'll go in front of that judge to try to get your conditions of release readdressed.
So the condition was no contact, that was it, that's all I,
Right.
okay, just no contact.
Thank you. That's all.
Thank you.
Stacy Reed is the next case. You qualify for the public defender. They'll be appointed to represent you. It's allegation you committed a battery upon a family or household members. That phrase is defined by law. Sir, you can raise your right hand the best you can. Do you swear or affirm the information you're going to tell us here today is true and correct?
Yes, sir.
All right, thank you. Yeah, you're going to have to get a lot closer to that. You must be like my height. So, all right. So your name, sir?
Jeffrey Parks.
You're the listed victim in this case. You know her better than all of us here. Are you asking me to order that she have no contact with you for your protection, or are you asking me to allow her to have some type of contact?
She can have contact.
Yeah, but none of us can hear you.
She can have contact.
All right, so you want that no hostile contact, or you want it to be limited by phone or email or something like that?
No hostile is fine.
Okay. So no, he heard me give a speech earlier, and I want to explain to you what the no hostile contact means, just so we're all on the same page. If I order the no hostile, and I haven't decided yet, the state and PD have a chance to ask Mr. Parks some questions, but no hostile, if I do that, would mean you could have as much contact with him as he allows you to have.
Okay.
Like, for example, if he were to say, don't yell at me, you couldn't yell at him. He can't say do the dishes or clean the room, but he can put restrictions on the contact, like don't smoke cigarettes around me, or don't, like I said, don't raise your voice, that's a good one, or don't touch me. You don't have to have any contact with him. You could just stay away from him forever. All I'm saying is, if you want to be around him and he's okay with that, then that would be perfectly fine if I allow the no hostile contact. So that's what no hostile contact means. But I haven't made a decision yet. The state and PD, I want them to ask some questions. I want to give them an opportunity to ask some questions. Go ahead.
Morning, sir. Do you think alcohol was a factor in the altercation?
Yes, but I'm not worried about my
I can't
safety
hear
or
him, Your
anything.
Honor. I'm sorry.
That's right. If you get closer to the mic, it's just
It's really hard to hear. Sorry, sir.
Yes.
But okay, so yes, you think alcohol was a factor.
Yes, it was.
Okay.
No further questions, Your Honor.
Defense?
Yes, are you afraid of Miss Reed?
Not at all.
No
No further questions from the defense, Judge.
Your Honor, the state would just ask for no drugs or alcohol as a condition of release.
Okay, with the victim here, does that mean she qualifies for pretrial release? I see that she didn't qualify because you all couldn't reach.
Right, Judge, we weren't able to verify her community ties. As in the previous cases, the charge does qualify, so if the court feels that that's appropriate, she would be released onto the program.
Okay, got it. Okay. So you won't have to post any money to get out of jail,
That would be awesome.
but the case is still pending. So no hostile, you'll be released on pretrial release, no hostile contact with this gentleman here, Jeffrey Parks. Don't possess any weapons or firearms, and don't possess or consume any alcohol or drugs that are not prescribed. You understand? All right.
I definitely do, thank you.
Your Honor, for pretrial's clarification, was that just no hostile and no drugs or alcohol?
Yes, ma'am.
Thank you, Judge.
He said no weapons.
Oh, yeah, no weapons or firearms.
Thank you.
The next case looks like, I think, Diane Stelly, is that you?
Yes.
Thank you. You qualify for the Public Defender's Office. They'll be appointed to represent you. Sir, raise your right hand to the best of your ability. I'll swear you in. You swear affirm the information you're going to tell us here today is true and correct?
I do.
Thank you. You can put your hand down. Tell us your name, please.
Chris Stelly.
All right, so you're listed as the listed victim in this case here. You probably know my speech better than as well as I do because I've said it so many times today. Are you asking me for your protection to order Diane Stelly to stay away from you, or do you want her to have contact with you?
I have questions regarding no
You're gonna have
hostile
to-
contact.
You probably heard us say to other people, you almost have to get so close to that microphone, it's embarrassing.
I just need a little more clarification on no hostile contact condition.
Okay.
So
let me do that now.
Well, there's a specific thing that you might not have explained. If I could clarify, if I request that she not come to the residence without, like, if I request that she has to live at a separate residence, and I also request that she not come to her present residence as unless approved or unless the family is okay with her coming there, does that apply under the no hostile contact condition?
Well, when you say the family, what family?
Myself and my daughter.
Okay. So, what?
Well, it can be my condition. It doesn't have to include my daughter.
So, what no hostile contact means is you could say, I don't want you to be around the house unless you first call before you come over to say you're coming, and I say yes. So if I say that would be included in the no hostile contact, like the person, like I can't say to my clerk, let's say we're a no hostile, if she had a no hostile contact restriction on her from me, she can't say, well, I'm just sitting here next to you. That's not hostile. That would still be hostile if I said, I don't want you to be around me.
Okay.
So but remember, she doesn't. Even if I allow the no hostile contact, she never has to talk to you ever again. So I just want you to understand that I can't force her to have any kind of contact. All the no hostile contact means is she can have as much contact with you as long as it doesn't violate your restrictions.
And so if my restrictions say that she's not to come to the house without my permission, that applies under that condition?
Right.
Okay.
Sure. But like I said, she doesn't have to have any. She could choose never to come over there ever again.
I understand that. The only other thing that wasn't clear in some of the other cases that I was witnessed was custody issues. I have a daughter that was a little bit shook up from this, and I'm trying to make sure that everybody's. And I'm sure in a few days everything's going to cool off and everything will be fine. But I'm trying to find out what are the conditions with the custody now that she's living in a separate residence.
Well, assuming that it ends up being the no hostile contact.
Yes.
Then what I would imagine isn't there someone who would be a good person to exchange the child through?
I'm sure that we could do it between ourselves without help.
Sure. So what happens is I don't get involved in child custody, child visitation, or child arrangements. But if I allow the no hostile contact, then you all can communicate about the exchange of the child.
Okay. Okay.
What gets complicated is if at some point in time you say, you know what, Diane Stelly, I want there to be no contact, she'd have to abide by that, and she'd have to get a court order to get involved in child custody. Court orders like family law cases, because family law can get involved in time sharing even if there's no divorce. There's a specific statute on point. So don't feel like there has to be a divorce in order for there to be a court order time sharing when people are separated.
Okay, therefore,
So you wanted to know hostile contact?
I'd like to request no hostile contact and also request that she resides at a different residence.
Maintain a separate residence. Okay, the prosecutor might have some questions, and then the defense might have some questions. I will advise you, though, that if, from what I read in the police report, it looks like they might have also, law enforcement, might have also submitted a packet to the state attorney's office to review where you all roles are switched, where you're the defendant and she's the listed victim. So, all right, so State, do you have any questions for him?
Nothing from the state, Your Honor.
Nothing from the defense judge.
Okay, so Ms. Stelly, no hostile contact, you understand what that means?
Sort of. I can have contact with them, but amicable.
You can't contact him without his you can't go to the house. Well, apparently he's telling you to maintain a separate residence. Okay, that's fine. Don't go over to that. He's saying out loud to us all now, don't go over to his house without talking to him first to verify it's okay. You don't have to have any contact with him at all, but if you want to, it has to be subject to his restrictions. Like he can't say, you have to come over wearing a red shirt. That's ridiculous. But he can say, don't yell at me, don't be around me if you've been consuming alcohol or tobacco. He can put restrictions, but you can also choose not to be around him at all.
Okay.
Remember, I'm not ordering you to be around him. So that's what no hostile contact means, but it's also the maintain separate residence, don't possess any weapons or firearms.
Okay.
If there's, I'm going to put, you're allowed to return one time. Well, no, but at some point in time, it might be where he says, don't even come over to the house, and you might have stuff there. So I have to put over there, if requested, the person can return one time with law enforcement to collect belongings.
Yeah.
I don't think that'll be an issue, but I'll put that in there just to be sure.
Yeah, please, Judge, because I have no place right now. I have nowhere to go.
I hear what you're saying, but I can't force him to let you at the house.
Right. I just
So
need to get my things in order to find a place, separate residence.
That's true, but you also, since the no hostile contact, you might call him up on the phone and he say, okay, and you all just work it out without law enforcement, but we'll put that in there just in case there's an issue.
So it's okay if it's okay with him?
What's that?
It's okay if it's okay with him?
Yeah,
Okay.
absolutely. So the,
Your Honor, if I may, I'm trying to avoid her having an escort come to the house. It's pretty embarrassing.
right, you don't need it. If you all can, we can imagine a scenario where she gets out of here, she calls you on the phone, and you all have a calm conversation, and you all arrange that amongst yourselves. That's perfectly fine. What I'm putting this in here is because sometimes people have these calm conversations, and suddenly they turn ugly, and the person says, like, for example, you might say, you know what? Don't talk to me ever again. Well, now she at least has the ability to go there one time with law enforcement in case you all can't work that out.
Okay.
All right, so.
And I'm sorry, Your Honor. Regarding the separate residence, that applies for how long?
Until the case is over unless modified by the court.
Is there any idea of how long the case might take?
I've seen cases that are over in a week because the state doesn't file charges, and I've seen cases I have one case going on down here that's from 2019. So I have no control over how long or how fast they go.
It somewhat depends on the complexity of it.
I could probably write a book on how long it depends. It's not an easy answer. But sometimes what happens is it might turn out that you both agree that you both go to some sort of diversion program, both do anger management classes together, and life goes on. Maybe that's what ends up happening because you might have a case also. It also could be, I don't know, I don't want to get too much involved. But if it's any time, if the other alternative is me just to not order that she maintain a separate residence, that I just say no hostile contact, and you at the beginning are telling her, don't live it, I want you to maintain a separate residence, and then you could modify that later. if it's just contained in the no hostile contact.
So if we only, if we only apply the no hostile contact, and I say, hey, you need to leave, you need to go find somewhere else to live, then the separate residence can apply through that?
Right.
Okay, so.
You prefer that?
Yeah, I'd like to be able to give her a chance to get her composure and to be okay.
Sure.
I don't know. It's all come so fast.
All right, so to be clear, so it'll be pretrial release. You won't have to post any money to get out of jail. No hostile contact. He's advising us today that he's telling you, don't come over to the house without calling him first and getting permission. It's maintained as separate residence right now, but that's not a condition of the court. That's part of his no hostile contact. And then that could always be modified later. If you all are smart people, you'll make sure you get it by text so that you'll have something in writing so there's no confusion later. But it gets complicated when someone says, you know what, let's try you coming over, and then 2 days later they say, you know what, it didn't work out, you need to leave. That's frustrating, I get it, but that's no hostile contact would then require you to leave if that happens.
Right, okay. Just a quick question. Does that mean I still have to maintain a separate residence?
For now,
correct?
because he's saying that, yeah.
Okay.
But
it's not a court order, it's because it's part of the no hostile contact.
Gotcha. But it's okay for me to get my things if it's okay.
When you get out of here, call him up.
Okay.
If you can work out that stuff, great. If not, there's at least going to be a provision that says you can go with law enforcement at your, okay.
Okay.
All right.
Thank
Good?
you.
Yep, good luck.
No hostage, no weapons, and she can go back one time.
Yeah,
With the maintained.
right. Let me see that thing. In the event the victim doesn't allow for a suicide.
No need to.
Hi there, you Jamie Alvarado.
Hello, I'm good. What was the question?
Your name, please?
Oh, Jamie Alvarado.
All right, thank you. You qualify for the public defender's office. They'll be appointed to represent you. The allegation is that you committed a grand theft and also battery. It was taken into custody on a warrant. And let's see. You are ordered to have no contact with the listed victim, and you're not allowed to return to where the victim, well, where the offense took place. And let's see here. All right. Your bond on count 1 is going to be $1,500, and the bond on count 2 is going to be $1,000. Plus, then you'll be on pretrial release with the conditions that I mentioned about the no contact and no return. Do you understand?
Yes, sir.
All right. Thank you.
Your Honor, the next one is a behavior. She was the one coughing, so we sent her back.
Does that mean we're doing a skipper?
Yes, sir.
Okay, let's see. So let's see. I don't even know why. Calandra Barreto, right? Barrett. That's who we're referring to.
Yes, sir.
Okay, so I'm just curious. So does she only have an IA because to be advised that Judge Wilson held her at no bond on the violation of pretrial release?
I mean, it's a violation of pretrial release condition, but it's a new arrest.
Right, this warrant was issued, Judge, as a violation of pretrial release, so she has not been heard on this case yet. However, for the court's knowledge, the detainer for the open case was closed out due to the fact that this new case was initiated by the new law offense. That the violation was initiated by the new law offense.
But there is
I'm
no
sorry.
new case, right? 'Cause it looks like she was put on release in 14896. And then
Yes.
she violated her conditions of release in 14896 and therefore was arrested on 14896.
Oh, no, Your Honor. What happened was she was arrested on 2020 MM 8977AO, and the supervising officer got a warrant signed for violation of pretrial release for 2020 CF 14896.
Right. And now she's, 2020 CF 14896 is still open.
Yes, Judge.
That's not a new case, right? Or is it a brand?
It's not a new case, she just has not been heard on the violation. It's a warrant, so she hasn't been heard on this violation of pretrial warrant.
It's an old case, and she was placed on pretrial with condition, and she violated her pretrial, whatever it was. So when she violated, the judge issued like a BOP, but it's not a BOP, it's like a
Sometimes I hear that they used to go, they just get taken to jail and they don't have an initial appearance, but I guess in Orange County they do. All right, so she's gonna be held at no bond in 14896. It's not a new case, it's just a case she already has in existence. She just needs to be told that that's why she's in jail. Is that
She
what
needs
this-
to have an initial appearance for this violation of pretrial release.
But it's not a new case. It's not a new charge of violations of pretrial release. Or is there a separate misdemeanor case number that exists charging her with violation of pretrial release?
So on 12/19, she was arrested for a new misdemeanor case and bonded out. The judge took no action on the case for which she was out on bond. However, her supervising officer got a warrant signed for violation of pretrial release because of that new arrest. Now she needs to be heard on her violation.
All right, so she'll be reset for tomorrow.
Okay.
Be held no bond on 14896, and the detainer was released already.
Thank you, Judge.
which one, the 8977 was no action? She coming back, just reset for everything tomorrow?
That
The
detainer
189
was closed due to the fact that that is what initiated this violation of pretrial release. No FAD required.
I mean, because it's on here, so that's why I was asking, is no action on that part of it, or
Today I could just say release the detainer.
say no action?
Hold her only on the 14896, and she's to have an IA solely on, but solely on the
Yes.
not that, the other
I mean,
thing.
the other, yes,
Yeah,
okay.
so there will be no orange sheet on there tomorrow.
Yes, okay.
But she already probably has a lawyer probably representing her. LaWanda Melody?
Yes, sir.
Hi there. All right, so you qualify for the public defender's office. They'll be appointed to represent you. It's alleged that you trafficked in fentanyl greater than 4 grams, that you trafficked in meth greater than 28 grams, that you trafficked in cocaine greater than 28 grams, that you trafficked in heroin greater than 4 grams, possessed fentanyl, possessed of cocaine with intent to sell or deliver, and possessed heroin with intent to sell or deliver, possessed methamphetamine with intent to sell or deliver, and possession of cannabis with intent to sell or deliver. And let's see, and you also have a case where there was a warrant charging petty theft with 2 priors and burglary of a structure. The public defender's office will represent you on both of those. And now I'm going to look at your, let's see what this is. All right, and then apparently, although we're not doing an initial appearance on it, apparently you have another case for a petty theft that the state's looking to serve you. All right. So on the arrest warrant case, the petty theft with 2 priors, your bond is $100. The burglary structure, the bond is $1,000. On the new case where there is probable cause for the offenses, you've had prior cases before, but you never failed to appear. You've had prior theft convictions. So but then again, the charges are serious, and based upon the seriousness of the charges, including the mandatory minimums that are involved, there's a fear of a person potentially running. So I'm going to set your bond at this amount. The one that's $1 million bond, I'm going to set at $50,000. On the trafficking in methamphetamines, I'll set at $50,000. The trafficking in cocaine will remain $50,000, and the trafficking in heroin will be $50,000, and then the remaining counts will be the $150. Some of these counts, she can be on pretrial release, but probably not the trafficking. Is that how that works?
Your Honor, I was just looking into the admin order regarding that. We can supervise trafficking charges, but we are unable to supervise anything that is a capital or life offense. So I was trying to get information on that trafficking and fentanyl. Maybe the state would have more input on that.
We'll just solve that problem. She'll be on pretrial release after she posts the bond on all the counts other than count 1.
And that was just on that second case, Judge, the 2021 CF 363?
Yes, ma'am.
Thank you, Judge.
Judge, just for the record, I know Your Honor already set the bond amounts, but my client has indicated that she does have a 15-year-old at home, and she does have a father who basically moved here from Mississippi for her to take care of him. He was diagnosed with cancer, and then she also she basically has custody of a 2-year-old because the mother of the 2-year-old passed. So if the court would be inclined, I know you already ruled on the bond amounts, but just for the record. And she's employed full-time. She's a manager of a rental company. And she has been here for 44 years.
Yeah, I appreciate all of that, and I also realize that luckily for people can go through the sureties, they can post a lot less than the amounts that I've told. If you try to post a bond and you're unable to do it, you're entitled to have a hearing to see for the judge to try to readdress your conditions of release. But I'm not ignoring what you're saying. I'm just saying that the numbers that I've done are clearly a lot lower than what was on the bond schedule. But the bond schedule is just for bond schedule, and I look at your criminal history, and I have to consider other conditions. So, all right, thank you.
Thank you, Judge.
Your Honor, what was the bond on count 2, trafficking in meth greater than 28 grams?
50,000.
Thank you, Madam Clerk.
So count 2 through 9, 50 plus pretrial release.
Correct. Yeah. And not on the other case.
Not on the other case.
Thank you, Judge.
Thank you.
Thank you, sir. Set the folder.
The next case is Melissa Brown. Hi there, you Miss Brown?
Yes, sir.
Allegations that you possess cocaine. There's probable cause to believe the offense occurred. Your bond is $1,000, and the public defender's office will be representing you. All right, do you understand?
Yes.
All right, thank you. The next case is Ivan Carujo. This one, there's a probable cause issue that maybe the state could point out. If I read this correctly, it just said that you're Mr. Carujo?
Yes, sir.
It just said some lady told the police officer something, and that's what the police officer relying on to believe that the person's a convicted felon. Now, I'm not saying he's not. I'm looking at the non-sworn to information that the jail provides. Oh, and he's currently on state probation. Sometimes what happens, sir, is, okay, let me start over again. You're here on 3 different cases. Can you afford an attorney, or do you need the services of the public defender?
For defenders, but I didn't know anything about 3 different cases, sir.
You didn't know it was 3 cases? So but I'm gonna go over that with you right now. 1 case charged an allegation of possession of a firearm by convicted felon. 1 charged grand theft, 3rd degree of a motor vehicle, and possession of ammunition by convicted felon. And the 3rd charge with regard to a credit card theft.
What?
Well, that's the least of all the 3 things. That's the least concerning charge. But anyway, but those are the three, you asked me what the three cases are, those are the three cases. And so there's probable cause for everything other than that he's a convicted felon as far as what's contained in the report, unless the state could point it out to me. But it seemed to me that it was just some lady said, not even some.
Some lady told the officer that he was a convicted felon.
Convicted felon, yeah, that's not enough.
Your
Although.
Honor, the state would ask for some additional time to get that information. However, it's up to your Honor's discretion.
It's just that this stuff right here that the jail provides, which shows that he isn't under oath, and I can't consider it for that purpose. For purposes of setting bond, I can, but not for that. So and let's see. Oh, and you might be in luck because he looks like he's got a detainer for violent felony offender of special concern, so he's here 5 days anyway.
If 5 business days, Judge, the supervising officer will have 5 business days to make a determination of whether or not to violate his probation that he's on through November 12th of 2024.
Your Honor, the state would again ask for 24 hours to reach
Yeah,
it. The state would ask for 24 hours to reach out to the officer and get a supplemental report.
Do they still have 2 sessions on I'm sorry, wrong person. Do they still have 2 sessions Monday through Friday? Or is it just 1 session?
Most times we do 2.
2, okay, so we'll put it for the afternoon session tomorrow.
All of them?
But yeah, we might as well put them all tomorrow. So there's probable cause for the credit card charge. There's probable cause for the grand theft on the second case, the 334 case. And just put the court's unable to find probable cause that he's a convicted felon. Right, exactly. But for now, we'll just stay the bond until tomorrow to be readdressed. 4,000.
So he can't post the bond,
Yeah. So, okay. So we're staying all the bonds. But the convicted felon issues are rolled till tomorrow. But we're gonna might as well have all 3 cases. And even if there's nothing preventing him from posting the bond, but the jail won't let him out because he's a violent felony offender of special concern. Was that your question?
Yes, Your Honor. If we may visit Bellamy, I just staffed with my supervisor supervising the trafficking charges, and he notified me that only counts 5 through 9 are eligible for pretrial supervision.
Okay, so we'll go back and fix that.
I apologize, Your Honor.
That's all right. So it's going to be the second session tomorrow. I don't know if you heard that part.
Second session, thank you. And it's the, I'm assuming it's for the PFCF charge for possession of firearm?
And ammunition, yeah.
And
Just whether or not, there's just no proof that he's not sufficient proof that he's a convicted felon under oath.
Right.
Hi there, you Anthony Crawford?
Yes, sir, Your Honor.
All right, thank you. You're here based on allegation that you committed grand theft of firearms. And based upon the paperwork here, you qualify for the public defender's office. And all right, so, and your bond on count 1 is going to be, let's see, Every once in a while I have questions how to read this document. So when it says at the top, it starts out with his Florida record, like for 0 FTAs is for Florida, but then when you go down further, then you can see like there's out-of-state FTAs. And
Yes, Judge. It appears that he's visiting from Washington, D.C., and he does, although this is his first Florida arrest, he does have extensive out-of-state conviction and arrest history.
Yeah, so your bond is going to be $5,000 on count 1 and $300 on count 2. If you can't afford to post it, your lawyer can always schedule a hearing in front of the judge assigned to the case to try to get you a lower bond, okay?
Yes, Your Honor.
All right, thank you. Hi there, you Darian Croft?
Yes.
The allegation is you carried a concealed firearm. There's probable cause to believe the offense occurred. The public defender's office will be appointed to represent you. Let's see. Local
He
edge.
qualifies for pretrial release, Your Honor.
All right, you won't have to post any money to get out of jail, but you're not allowed to possess any weapons or firearms. Do you understand?
Yes.
Right? Just because you don't have to post money to get out of jail doesn't mean that the charges are any less serious. It means you just
Yes.
don't have to.
I understand, yes.
All right, thank you. Have a good day.
Excuse me.
Yep. Your name, please?
Clarence Lamont to the Coastie, sir.
All right, thank you. So you have a charge of possession of firearm by convicted felon and possession of a controlled substance. There's probable cause to believe the offense has occurred. The public defender's office will be appointed to represent you. And now I'm going to address, let's see. So your bond is going to be $4,000 on count one and $1,000 on count two. But if you post the bond, they're not going to release you right away because you have that outstanding case, that case number 2020 CF 10285 AO. That case is going to hold you in jail until the judge assigned to that case readdresses your condition of release. You're entitled to conditions of release, but you still have to go back in front of that judge to readdress the conditions of release in that other case from August of last year. Do you understand?
Yes, sir.
All right, so you already have a lawyer representing you in that other case, right? Like maybe it's the public defender or private attorney, either one?
I'm getting power of attorney right now, sir.
Okay, fair enough, okay. Thank you. Right. He was previously? Okay. Let's do that revocation order. All right, hi, your name, please?
Carice Duncan.
Thank you. All right, so you're taken into custody for trespass on property after warning and burglary to an unoccupied structure, criminal mischief, introducing contraband to a county detention facility, and possession of drug paraphernalia. You qualify for the public defender's office. They'll be appointed to represent you. And let's see. All right. There's probable cause for the offenses, and the bonds and remain $2,500 for the burglary. No return to that scene of that offense. The criminal mischief is $250. Introduction to contraband to a county detention facility is $1,000. Possession of drug paraphernalia is $500. And the trespass after warning is $500. In each of these two cases, I'm going to add pretrial release after you post the bond. You're going to now be able to post the bond. I'm not revoking the conditions of release in your outstanding case, but you will be on pretrial release after you post the bond in the new case. Do you understand?
Where's my bonds on?
You mean what's the total of all that?
No, the two of them I got pre-trial release, right?
After you post the bond, then you'll be on pretrial release.
Wait, where's my total for the bond?
All right, the clerk will tell you the numbers, and I don't know if she's got a calculator there.
On the trespass is 500. On the other case, it's 2,500, 250, 1,500.
If you can't afford to post the bond, after trying, you can go in front of the judge assigned to the case to try to readdress conditions of release, okay?
Your Honor, will she only be supervised on the felony case?
Both cases.
Thank you, Judge.
Your name, please? I couldn't hear you through the mask. What's your name, please?
Christian Estevez.
All right, thank you. You qualify for the public defender's office. They'll be appointed to represent you in this case, where it's alleged that you possess cocaine with intent to sell or deliver, that you conspire to sell or deliver cocaine, that you possess cocaine, and that you possess drug paraphernalia. Now I'm looking at your criminal history, if any. Let's see. All right, so there is probable cause for the offenses and your bonds will remain 15,000 on count 1, 150 on count 2, 150 on count 3, 100 on count 4. Then in case number 2020 CF 1014060, but not the other one, the 14060 only, you're going to have to go back in front of the judge assigned to the case to readdress conditions of release, because that case is going to be holding you in jail too, because the last drug charge case wasn't sufficient to keep there from being probable cause for a new offense, but I'm not doing anything in 2020 CF 4573. Do you already have a lawyer representing you in the 14060 case?
Yes.
Public defender or private attorney?
It's a public defender.
Okay, they'll be able to go back in front of the judge to try to readdress your conditions of release.
And what was the bond amount on for one, Your Honor?
The new one, it stayed.
Yes.
Yeah, it's just stayed the bond.
Oh, okay, okay. Okay, thank you.
Yes, ma'am.
Step in. Step to the podium.
Hi there, your name, please?
Mayor John.
All right, so there's one case I had ahead of yours. I'm just going to see maybe they bonded out. Stanley Florimond?
Bonded out. We bonded. That was a PC bond. I'm excited.
All right, you have two cases here today, sir. You qualify for the public defender, so there'll be you're Tanel Giles, you said, right?
Yes, sir.
Yeah, you can step on up. Two cases here. You have one case where there was allegedly you had failed to appear for court and for a charge of a drug charge. The bond is $1,000 on count 1 and $100. That's a case number 2020 CF 6111. And then you have a case charges of possession of MDMA and resisting without violence. There's probable cause. The bond's $1,000 on count 1 and $100 on count 2. But you're out on bond on a MDMA case already in case number 2020 CF 1330680. You're going to have to go back in front of the judge assigned to the case to readdress conditions of release in that case, because you're going to be held on that case until you do. Do you already have a lawyer representing you in that case? Maybe the public defender's office lawyers? Okay, so they'll be able to go in front of the judge assigned to the case to readdress your conditions of release. You understand? All right, thank you. Hi there, your name, please?
Kenneth Lee.
All right. You have two cases. You have one case where it's alleged that you committed the offense of a DUI and also that you refused to submit to the test. Now, luckily, the state recently was in county court. Have they changed the law to no longer require a prior refusal? Because it looks like it's not alleging a prior refusal. And I didn't, but hold on, the driving record might be here.
I have it as well, Your Honor. One moment.
Yes, Your Honor. The defendant has a refusal May 15th, 2003.
Okay, so that's on his driving record that is printed out here, but I don't know if this driving record, does it go into the court file or not go into?
That's just for your purposes, Judge.
So it doesn't go in the court file?
Madam Clerk, do you know the answer to that?
No, we don't.
No, it don't, she says. So, but did you see that in the police report anywhere?
Your Honor, I do not see anything about checking David for a prior refusal, Your Honor.
And let's see.
As far as I saw, Judge, it was just for the refusal once he got to the breath test center. And I did have a PC challenge to the DUI only because I didn't see any facts alleging a DUI before he was brought to the breath test center. It was the same police report for the other case that he has.
All right, I believe there's probable cause for count 2 on the DUI report. The state would ask for 24 hours to get a supplemental report for how the officer knew he had a prior refusal.
Right, so on the refusal count only, we'll roll till tomorrow for determination of probable cause. But I'm going to find that there is probable cause on the DUI. And now, I mean, we're spending a lot of time on the least serious of all the charges here. The other one is possession of, or aggravated stalking, the aggravated assault, and the possession of weapon or ammunition by a convicted felon. And so there is probable cause for those offenses. So I want to make sure you understand what no contact means. It's just easier for me to take a couple minutes to explain what no contact is, as opposed to a person getting arrested for violation of the no contact order. No contact means none at all, no good or bad. If you won the Powerball yesterday, I don't know if anyone did, but if you won the Powerball yesterday or the other day and won $500 million and you gave it to the victim, they'd be able to keep it and you'd be in jail for violating the no contact order. It doesn't matter that probably everyone else in the world would love to have the $500 million. So it's just an example of any contact is a violation of the no contact order. Now I'm looking at your prior criminal history for me to set conditions of release. Oh wait, maybe I have a note here about the convicted felon part also. Hold on a moment.
That in paragraph 4, and has been convicted of a felony in the courts of this state.
Right, so, yeah, that one's not to be rolled also, because that doesn't say where his source was. Like, did he read it on a police report? Was it that same lady in the last case who's just going around telling people that people are convicted felon or? So, with regard to the count 1 and, just count 1, the possession by weapon or ammunition by convicted felon, that's gonna be reset for determination of probable cause. Afternoon session tomorrow. But there is probable cause for the other two charges, the aggravated stalking and aggravated assault with a weapon. So no contact with the victim, don't possess any weapons or firearms, don't go to where the victim resides, don't possess or consume any alcohol. And the bond on count 2 is going to be $10,000, and the bond on count 3, $5,000. I'm going to give you bond on count number 1 today, but it's going to be readdressed tomorrow. If you're still here, I don't want to hold you at no bond in case you want to bond out. But on that one, the bond on count 1 is going to be $2,500, but to be readdressed tomorrow. And then on the DUI, the bond is $500. The refusal is going to be $500, but we're going to readdress the PC on refusal tomorrow afternoon also, just because there's no driving record in the court file.
Madam Clerk, what was the bond on count 2 and 3 on the aggravated stalking, aggravated assault?
10,000, 5,000.
Thank you.
Your Honor, on Bellamy Lawanda, you ordered bond and pretrial release. Would you be wanting any conditions with the pretrial release program supervision?
I hear something, but I can't tell where it's coming from.
Sorry, Judge. On Bellamy, you ordered bond and pretrial release. You didn't state any conditions. Would you be wanting any conditions with that supervision?
Bellamy was a trafficking case?
Yes.
If I didn't say it, then I can't add it now.
Okay.
But thank you. Hi there, your name, please?
Rico Lopez.
All right. There's probable cause to believe that you possess cocaine. The bond on the case is going to be $1,000. I'm not going to revoke the conditions of release in the other case, but that doesn't mean the state won't go in front of the judge assigned to the case to try to have it revoked. Do you understand? You can, all right. But instead of revoking, I'm going to put you on pretrial release with the condition, don't possess or consume any drugs that are not lawfully prescribed, so they'll drug test you.
Okay.
So, all right. So post the bond, then you'll be on release. Pretrial release, yeah. Isn't that, I'm just curious, isn't that a standard condition about the random UA? Because I said he's going to be tested,
It's
but
part of the program that they can be tested, but if you order random RUA, then they
will.
can set them up
Oh, yeah.
for random.
Yeah, that's what I told him, he'll be tested. Your name, please, your name?
Your Honor, was that with RUA?
Yes, please.
Thank you.
Your name, sir?
Lugo Rosario, Jonathan Luis.
All right. You're taken into custody for possession of cocaine with intent to sell or deliver, conspiracy to sell or deliver, possession of cocaine, unlawful use of a two-way communication device, and possession of drug paraphernalia. You qualify for the public defender's office. They'll be appointed to represent you. I'm here to set conditions of release. Okay. I see the prior criminal history. Your attorney has it also, and based upon that, I'm going to leave the conditions of release. That was the 15,000, the 150, 150, 150, and the 100. Do you understand?
Yes, sir.
All right, thank you.
Your Honor, Maralt's is behavior.
All right, let's see what we got. So put on there's probable cause to believe the offense occurred, and we'll leave the $1,000 bond and we'll reset it for tomorrow afternoon session. See if he didn't fill out the PD paperwork, so we'll roll it for that determination tomorrow also. How are you, Matthew Orr?
Yes, sir.
Yeah, step on up to the podium, please.
Can I speak, sir?
Hold on one moment.
Okay.
So appoint the office of the public defender to represent you. You have two cases, a driving while license suspended with knowledge. There's probable cause to believe that offense occurred. And then their next one is possession of a weapon by convicted felon. There's probable cause to believe that offense occurred. So I'll give you a chance to speak to your attorney before you say anything to me. Whoops, oh yeah, the third case, resisting without violence. And there's probable cause.
I answered his question, Judge.
All right, thank you. All right, so the, on the possession of, charge of, by a convicted felon, the bond's gonna be $10,000. On the driving while license, on the driving while license suspended charge, the bond will be $500. On the resisting without, $500. With regard to the case number 2020 CT 3866AO, that case, the similar charge of what you just picked up again, that case is gonna hold you in jail at no bond until you go back in front of the judge assigned to the case to readdress conditions of release on the criminal traffic case. I'm not changing the conditions of release on the 2020 CF 8831 case. All right, thank you. Have a good day. All right, next case is Precious Santiago. All right, you qualify for the public defender's office. They'll be appointed to represent you in the case. You're taken into custody on an arrest warrant for the charge of child abuse and 3 counts of battery. Now I'm here to set, you've been held at no bond, but now, well, let's see, you've been held at 10,000, 1,000, 1,000, but now I'm going to see prior criminal history, if any, and then for me to set conditions of release.
Precious Santiago? Oh.
You have a pending case that you might not be aware of, a petty theft that the state's perfect, just like that co-defendant, the same co-defendant in this case, same thing. They both have them, the petty theft must be related.
Sir?
So I know you want to say something, but before you do, I'm going to let you say it first to your lawyer before you say something that could hurt your case.
Okay.
Okay. Were you able to answer whatever question you had?
Yes.
All right, so see your criminal history. The count 1 is going to be $5,000 plus pretrial release. Counts 2, 3, and 4 each $1,000. No return to the location of this offense that let's see, it's called New York. Hold on. New York Styles, and no contact with any of the listed victims. Those will be your conditions of pretrial release once you post the bond. Do you understand?
Yes, sir.
All right.
So just for count 1, you want people out on
All of them, yeah. So no return, no contact.
I'm sorry, I'm struggling to hear the clarifications being made.
I'm sorry.
She was making sure that it was on all counts.
The PTR?
Right.
Child abuse is not eligible
There you
for
go.
pretrial supervision.
All right, counts 2, 3, and 4.
Just count 1?
No, child abuse, I can't do PTR for count 1, so.
Count 2, 3, and 4.
Got it. Sometimes I feel when I was talking here, I can hear my echo, but then it goes away as if someone's turning down the microphone, which I know is not happening. All right, thank you. Next case is Kiana Slaughter. Hopefully I'm pronouncing your name correctly.
Your Honor, I apologize to go back to Santiago. Were there any conditions?
No return to that New York Styles, and then no contact with the victims.
Thank you, Judge.
All right, Ms. Slaughter, you're taken into custody for carrying a concealed firearm. There's probable cause to believe the offense occurred, and you might qualify for pretrial release. No? Let's see, why not?
Your Honor, her bond has been posted. It's just she hasn't been identified, so the bond will be processed and she'll be released after her fingerprints are cleared.
All right, did you hear all that? Assuming you really are who we think you are, you'll be released shortly. All right, thank you.
So we're not IAM?
So no, nothing to do with IAs.
Sorry?
So we're not doing her IA?
You just write in there, bond previously posted, no further action.
When going post?
What? Bond stayed?
Put bond posted, yeah.
Yeah, just put bond previously posted, no further action.
Yes, Your Honor.
Hi there, you Christopher Smith?
Yes, sir.
All right. The allegation here today is that you possess methamphetamine with intent to sell or deliver, that you simply possessed it, that you possess fentanyl, that you possessed oxycodone, that you possess alprazolam, that you had a driving while license suspended charge, and a possession of less than 20 grams of cannabis. The clerk's office determined that you don't qualify for the public defender's office. You have an outstanding case of that 2020 CF 13857. Do you already have a lawyer representing you in that case? It could be the PD, yeah, maybe it's no one.
I believe.
Oh, the clerk says you don't have anyone representing you.
Oh, maybe it's in no file yet.
Oh, no, you don't have it. You brought it out before.
Has a court date? Oh, an arraignment when?
14.
Oh, arraignment in a couple days. Oh, that's good.
We'll likely get appointed at arraignment.
Is it fair to say that if you were in jail and not able to get out, that you would not be able to afford a lawyer? Is that true? Is that it?
Oh, yes.
Okay. So I'll appoint the public defender to represent you. There's probable cause to believe the offense occurred, and the bond on the case is going to be okay. On count number 1, the bond on set is $5,000. The bond on counts 2, 3, 4, 5, 6 are $150, and the bond on count 7 is $100. Now, so you have a bond in this new case, but that 2020 CF 13857AO, since it's a similar drug charge, you're going to have to go in front of that judge again to try to, well, you haven't seen a judge, but you're going to have to go in front of the judge to address conditions of release, because the previous conditions of release were not good enough to prevent there being probable cause for a new offense occurring. I'll appoint the public defender to represent you in that case also, so that they can go in front of the judge. I see your next court date is, on that case, is January 14th. Today is the 10th, so you have a court date in 4 days for an arraignment. Oh, although the clerk said because you're in jail, that might affect the date. So who does the in-jail arraignments? Does Judge Lattimore do this?
Yeah. So I reset it for in-jail arraignment in that division, and then we'll go from there.
How fast do they go, do you know?
Pretty good, pretty fine.
So the next week or so, you think?
Yeah.
All right, so if in the event that the public defender's office doesn't get you a bond hearing in front of Judge
Lattimore.
No, the one, the side
the bond
case.
here, I'm sorry, 7 King, Division 20.
I know he used to be Wooten. Is it still Wooten again?
Yeah, I think Wooten went back.
He went back to the same division. How long? Okay. In the event that your attorneys can't get you a bond hearing in front of Judge Wooten before your arraignment is going to be within a week or so anyway of in-jail arraignment. So they could, in front of Judge Lattimore. So anyway, so you have lawyers working on it to try to get you a bond again, okay? Does that make sense? So you have a bond on the new case, but your old bond doesn't exist anymore, and your lawyer's gonna have to go back in front of, and I say go back, but I shouldn't say that. You need to go in front of the judge assigned to the case to try to get you a bond. Because you were out on bond on a drug case, probable cause to believe a new drug case occurred, so now you're gonna have to go back in front of the judge in Division 20 to try to get conditions of release. You're entitled to conditions of release, but it has to be that judge that sets them on that older case. All right, thank you. Next case is Will Vern. Tell us how to pronounce your last name, please.
Vernellis.
All right. You have 2 cases here today. You have a driving without a valid driver's license, with also an attaching tag not assigned. And then you have a separate case of possession of firearm by convicted felon, carrying a concealed firearm, and possession of ammunition by convicted felon. So give me just a moment to look at your prior criminal history for me to address the conditions of release. right, so your bond on count 1 is going to be $2,500, $150 on count 2 and count 3. On the no valid driver's license and attaching title not assigned, the bond will remain $500 and $100. And your lawyer will, the public defender's office will be defending you on the case, and there is probable cause for the offenses. Do you understand, sir?
Yes, sir.
All right, thank you. All right, your name, please?
Drew Miller.
All right, thank you. Now, stay right there at the podium. There was a couple cases ahead of yours that I just need to announce what happened, or find out what happened. We had did Garcia Munoz, did we already address that one, or did they bond out? Was okay. And then there was a Brittany Carpuck, she bond out? Her number is...
Your Honor, the first 3 cases were on the move-up docket. Carpuck, we did... Oh, never mind, Your Honor.
So her number was 767.
Bonded, Your Honor.
All right, thank you. All right, so Mr. Miller, it's alleged that you drove under the influence of alcohol to the extent, or a controlled substance to the extent that your normal faculties were impaired, and also that you drove while your license was canceled, suspended, or revoked, and that you knew the status of your driver's license. You qualify for the public defender's office, so they'll be appointed to represent you. And there is probable cause to believe the offenses occurred. All right, State, what is the status of 2020 CT 6423? It looks like the rest was back in October, and I'd like to think something has happened.
6243?
Yeah, 2020 CT 6423AO.
Your Honor, this case is scheduled for PTC tomorrow, so I assume it was charged by citation and therefore going to trial shortly after PTC
All
tomorrow.
right. So Division 83, who's that?
I have it under Judge Laurent, Your Honor.
That's all.
Anyway, so you think it's Judge Laurent is who you have it?
Laurent, yes, Your Honor.
Okay. And is it showing he has a lawyer on that case?
Matthew Ferry, Your Honor.
Okay. Have you let your lawyer know that you're here in custody?
I don't. No.
Okay.
You know the microphone where the defendant standing, she didn't allow
The humming sound.
You heard it? Okay.
I'm sorry. Did you say pretrial conference tomorrow?
Yes, Your Honor, 111.
I'm gonna just email Judge Lorenz so she knows if you're not in front of her that she doesn't tomorrow that she doesn't issue a capias. Let's see.
And that was charged by citation, Your Honor, so it is filed.
What's that?
It was charged by citation, so it may not say filed, but we don't file on citations.
I just don't want her to think that there's a failure to appear. All right, so Mr. Miller, on the case that you have, the 2020 CT 6423AO, it's important you let your lawyer know that you're here because you're going to need to go back in front of Judge Laurent to address the conditions of release, because that case is holding you at no bond, even though you have a bond in the new case of the 500 and 500, but the case that you have pending, you need to readdress conditions of release. You already have a lawyer, they know how to do it. You're entitled to conditions of release, but they have to be readdressed by the judge assigned to the case. All right, so make sure you let your lawyer know. I emailed emailed the judge assigned to the case so that if for some reason you're not brought over before her tomorrow, that she knows you're not able to make it over there, so that she doesn't issue a capias and that become a little bit of an issue. But it'll be helpful if you just let your lawyer know that you're here, okay? Yep. All right, thank you. All right, your name, please?
Over Carter.
Okay. Before I address your case, stay right there, but let me just ask the jail. 770?
Let me vote for Your Honor. What is the booking number that you have, Judge?
2100770 on a Jose Manuel Rojas Ramirez.
He bonded, Judge.
Okay, thank you. Okay. And you said your name was Carter, right?
Yes, sir.
Okay, so, yeah, there's one right before you, but stay right there. What happened?
Alan was a refusal.
Alan was a refusal. Let's see what's going on there. All right, so put on the paperwork, there's probable cause to believe the offense occurred. We'll roll it over till tomorrow afternoon to see if he attends. And stay the bond for now, and we'll then let the judge tomorrow readdress whether the conditions of release and whether or not to revoke in the other case. All right, so Mr. Carter, sorry for the delay.
It's okay.
So the allegations is that you trespass in an occupied structure or curtilage. The maximum penalty, I'd have to look to double check whether it's 6 days in jail or a $1,000 fine. Sometimes the state makes a plea offer on these kind of cases. Sometimes they don't. It doesn't hurt to hear a plea offer, but do you want to hear the plea offer?
Judge, I actually had a PC challenge to this one.
All right, go
For
ahead.
the trespass, there was, by virtue of it being a Toyota dealership, it was open during normal business hours. The allegation isn't that it's actually a group of them that I'm going to be making the same challenge to. They were never told to leave, so it's not a refusal to leave after warning. They were allowed to be on the premises by virtue of it being a business open during normal business hours. They just happened to use a different manner of arriving on the property than, let's say, the front entrance from the street.
Yeah, they jumped the fence. The question is, what does that mean? So do you have any idea? Do you want me to roll it till tomorrow? There was one other case that we passed that bonded out where this issue was up, but you didn't have to raise it.
Right. And I believe there's 2 more on the docket.
Yeah, Your Honor.
It just,
Your Honor, I would just point you to the last line of the first paragraph, which says the defendant was seen in an area of the business fenced off from the general public. I believe that's enough for probable cause, Your Honor.
all right, yeah, your response to that part?
I'm sorry, was that to me, Judge?
Yes, ma'am.
I apologize.
It just said,
I mean, it's fenced off from the general public, Judge, but there's no allegation that they weren't allowed to I just don't see anything that they were in a place that they were unauthorized to be in, aside from the business being a normal business that they could have been walking around, and that's what the affidavit says, that they were all just walking around at this point. They just happened to hop a fence to get in.
That other case earlier must not have, that we skipped because he bonded out, must not have had that language about, because I read all the felonies, but I don't read the misdemeanors until we address them each individually. And the one on the felony must not have had that sentence in there. But if it's fenced off from the general public, it's at least probable cause for trespass. That doesn't mean he has to take any plea offer. Regardless of whether he takes a plea offer or not, I'm not revoking the conditions of release in that prior case. He's entitled to a bond, to bond out of jail. On this case here, the bond would be $500 and no return to the scene. Does he want to hear a plea offer? He just wants to post the bond. But this doesn't prevent the state from seeking the judge in Division 14 from trying to revoke the conditions of release.
Your Honor, there's no offer at this time.
All right, there you go. So post a bond. After you post the bond, don't return to the scene of the offense.
Yes.
No action on this out on bond case, Judge?
Yes, ma'am. Thank you. All right, Kevin Joseph. All right, you're wanted out of St. Lucie County for a case in which there's no bond. And then you have an Orange County case here where the bond is, the charge is that you committed a trespass. All right, so same argument as the last case?
Yes, Judge.
Let me see if this has that same language. So this one doesn't have that language, so maybe the state can see it.
And I based this challenge on that police report from the first because they all look the same, but I guess some of them have the language of the last one and some of them don't.
Oh, well, this says due to the business being closed at the time of the incident. All right, that's sufficient. To do the business being closed is sufficient for the trespass. All right, so the state no plea offer, right?
There's no offer at this time, Your Honor.
So the bond is $1,000. And then once you post the bond, that St. Lucie County will be told to come and get you.
I apologize, Judge.
I said, this one has, I mean, for some reason, all these reports have different
I know,
language.
it trips me up too, Judge, because I definitely based it on that first one,
Right.
and they all have different language now.
So, all right, so there is probable cause. They have a $1,000 bond. Once you post the bond, St. Lucie County will come and get you for that other case, okay? All right, thank you, sir. The next case is Mr. Major.
Mr. Major was a bond. He was a bond.
Bonded, okay. Just,
Wait, I'm sorry, now I'm a little confused, Your Honor. We just did Carter, and then we just did Major, Your Honor, right?
Mr. Major bonded.
We did
We did
Joseph.
just Joseph. Joseph was $1,000, Major bonded, and we did Lockhart this morning. As a move up.
I don't have.
What's that?
Right, Carter was the first one from the.
We did Joseph,
I don't have Joseph's arrest affidavit. Oh, I do right here. This was Joseph.
Major is bonded.
Did you see your last case? This is just the picture of it? see. I see what that issue is. There's different police officers writing the different reports, and like on Mr. Major, I didn't see anything about being closed or not closed. It's just, got it, okay. So now, sir, you could step up to the podium and tell us your name, please.
My name is Kadeem Bond Wright.
All right, Mr. Wright, it's alleged that you trespass, okay, this is the same, let's see. Nope, trespass out of 7-Eleven. Okay. We're going to let you hear a plea offer. You don't have to accept the plea offer. Whether if you accept the plea offer, it'll resolve the case. If you turn down the plea offer, if the state's willing to make one, then it just means you'll be able to bond out of jail. Do you want to hear a plea offer, or you just want to bond out of jail?
I'd like to hear a plea offer first, sir.
State.
Your Honor, the state's offer in this case is an adjudication of guilt for trespassing, credit for time served, and no return to the 7-Eleven on 851 Lee Road, with court costs and the cost of prosecution.
So I found out yesterday that total is $273. You'd be adjudicated guilty, sentenced to 2 days in jail. You'd be released today, and then you order not to return to that 7-Eleven, and then you'd have to pay that money, and we'd give you 1 year to pay it. Or you could turn down the offer and just bond out of jail.
I'll take the offer, sir.
You want to take the offer? Okay.
May I just quickly inquire something?
Yeah, go ahead.
He does have 2 open cases, Judge.
Whether he takes the plea or not takes the plea, I'm going to release the hold. All right, you want to take the plea?
Yes, sir.
All right. Just want to go over some rights that you give up by entering a plea of guilty or no contest. Obviously, there won't be a trial, so as you can imagine, anything you've ever seen in a trial wouldn't apply to you. Like, the state wouldn't have to prove the allegations against you beyond a reasonable doubt. You wouldn't be testifying or remaining silent. You would not have a lawyer challenging and cross-examining the witnesses and evidence against you. Do you understand all of that?
Yes, sir.
A plea of guilty means you admit it. No contest means I don't admit it, but I don't deny it. Whether you plead guilty or no contest, the sentence is the same. A plea of not guilty means you deny the allegations. You prefer to fight it in court and keep all those rights. You understand that?
Yes, sir.
To the allegation that you committed the trespass at the 7-Eleven yesterday, do you plead guilty, not guilty, no contest?
No contest, sir.
And in the no contest plea because you believe that's the best way to resolve the case for you?
Well, yes, sir.
I'll find that you knowingly, freely, voluntarily, and intelligently have waived your constitutional rights with an understanding of the nature of the allegations and consequence of the plea, and there's a factual basis to have accepted the plea. And I'll give you the sentence that I told you to receive, and you'll be released today. Those other cases aren't going to hold you in jail, but you still have those other cases pending. You understand?
Yes, sir.
You have 30 days to appeal the judgment sentence of the court. If you do so, you must do so in writing to the clerk of the court. If you can't afford an attorney, one will be appointed to represent you. All right?
Yes, sir.
All right. Thank you. Good luck.
Thank you, Judge.
Mr. Camacho?
Yes, sir.
So I'm here to tell you that Seminole County has a warrant for your arrest. The bond is $500. Seminole County will be told to come and pick you up, and they should get you in the next couple days. It was for a driving while license suspended charge. Do you want me to appoint the public defender here until they transport you? No. No? Okay. Go ahead. Good luck, sir. Hi there, you Mr. Risper?
Yes, sir.
I'm here to tell you that we're picked up for a warrant for your arrest from another jurisdiction, Okeechobee County. They're going to be told to come and get you. The bond is no bond. They should pick you up by the end of the week, okay?
All right.
Do you want me to appoint a public defender here and to at least represent you here to make sure that they pick you up?
Yes, sir.
All right, no harm in that. All right, thank you. Your name, please?
Daniel Fuentes.
All right, thank you. You're here today on an allegation of disorderly conduct. It's punishable up to 60 days in jail and a $500 fine. Sometimes people want to hear a plea offer to try to resolve their case. Other people just want to bond out of jail. Do you want to hear a plea offer?
Sure.
All right, thank you. Doesn't hurt to hear it. You can always
Yeah.
say no. All right, State?
Your Honor, the state's offer is an adjudication, credit for time served, no return to the O-Sphere Neighborhood Grill with court costs and costs of prosecution.
So adjudication, 2 days in jail that you've already done. You'd be released today. You would be ordered not to return to that location, and the costs are $273, and it would give you 1 year to pay. Or you could turn it down, bond out of jail. It's completely up to you.
He's indicated that he wants to accept the plea offer.
Okay, 1 moment. Any person who enters a plea gives up certain rights. Like imagine if you've ever seen a trial on TV, all those rights, like there wouldn't be a trial, the state wouldn't bring their witnesses in, you wouldn't bring witnesses to testify for you, you wouldn't have a lawyer challenging or cross-examining the evidence against you, you wouldn't be able to either testify or remain silent. Do you understand all of that?
I do.
And knowing all that, you want to waive those rights and accept the plea offer from the state?
Yes.
To the allegation that yesterday you committed the offense of disorderly conduct, do you plead guilty, not guilty, or no contest?
No contest.
Are you entering the no contest plea because you believe that's the best way to resolve the case for you? Or because you believe you're guilty, or both?
Best interest.
All right, I'll find that you knowingly, freely, and voluntarily have entered your plea with an understanding of the nature of the allegations and consequences of the plea. There's a factual basis to accept the plea, and I'll give you the sentence that I told you to receive. Do you have any questions?
No.
You have 30 days to appeal. If you do so, you must do so in writing to the clerk. If you can't afford an attorney, one will be appointed to represent you. All right, good luck.
Thank you. Thank you.
Is there another person?
No, that's Grant on the bond.
Abigail Grant bonded, okay.
She was gonna get withhold.
Oh, really? Well, mark that in your file for arraignment.
She doesn't get it. She's not in any trouble.
All right, so